I assume everybody can hear me. True? Okay, good, good. Next up is Texas Rule of Appellate Procedure 24.1B2. And Pam, the ever-present Pam Barron, and the ever-present Bill Boyce, who's going to lead us in this?
This is my black bean here.
All right.
This is handout F in your materials, 24.1B2, which involves the content and approval of supersedious bonds. Right now, to be effective, a supersedious bond must first be approved by the trial court clerk. And the court referred us this matter because they had heard from some practitioners that they were running into issues getting approval of the trial court clerk in order to stop execution of a judgment, and also input from some clerks who said they felt a little uncomfortable with their role in approving bonds. So to cut to the chase, our subcommittee explored a lot of options, which I'm going to lay out for you, but so that you can get completely freaked out up front, our unanimous recommendation is to amend the rule to provide that supersedious bonds are effective upon filing and no longer require approval of the clerk, and that if a party has some problem with the bond, they can take it up with the trial court judge. So to give you some background, and I want to say we have 3 great resources, I hope, on this meeting. We have Sharina Gilliland, who just participated in our last discussion, District Clerk of Parker County, and also Nancy Rister, who is District Clerk of Williamson County. And I want to apologize to her because I did not recognize her as a member of this committee on in my memo, but she is certainly one of many esteemed members. And we also have Professor Elaine Carlson, who is pretty uniformly considered to be the state's expert on supersedious bonds. So to give you a little background, I did follow up with Jackie to get a little more sense of what the comments were that the court had been receiving. And she put me in touch with Reagan Simpson. He used to be a partner at Fulbright and Jaworski. I think many of you know him, and he's now, I think, head of the appellate practice group at Yetter Coleman. And I've attached his letter, which he was nice enough to send in, that outlines some problems that he's encountered mostly in rural counties where the clerk's office is not either familiar with or not equipped to deal with supersedious judgments in large cases where it's very important to the defendant to get that approved in order to stop execution. He's had problems with, I'm not sure it made it into his letter, but he did have one case where they started taking the trucks. And he's had one where he had to threaten the clerk with mandamus, or where the clerk said, I'm not going to approve it, it has to go to the judge. Reagan's suggestion was that we move to a federal practice, which is that all supersedious bonds in federal court are approved by the district judge. There are a lot of reasons. Well, I'll get into why we didn't think that was a great idea in a minute. And then Jackie also reached out to our district clerk members, both of whom said, why can't we just accept it? And then if people have problems, take it up to the judge. There's not much we do in terms of examining and approving the bond. We can do a little Google search to see if the surety's okay. And then I also did get, with Justice Christopher's kind assistance, a copy of the policies. They're actually very detailed from the Harris County District Clerk, which is, they have their own section in the clerk's office for post-judgment matters. They're very well equipped to handle this. They have an extensive checklist. Kind of the 2 major things they do is they do check the Federal Register to make sure that the surety is approved and that the amount of the bond is consistent with what they are approved to provide as surety. And they also check that the bond amount complies with the provisions of the statute. There are some other relevant rules, and you should know that if a party files a cash bond, the clerk has no role in approving it. So we're treating supersedeas bonds different from cash bonds. And also, if a party files a net worth affidavit and says my net worth is $5, clerk, here's $5, the clerk really has no role in that either. And a party who wants to challenge the amount of the bond or the net worth, again, has to file a motion and take it to the trial court judge. So just in further background, the approval by the clerk has been Texas law since the late 1800s. That kind of came as a surprise to me when I look back at this. It was statutory, and it's discretion that is not unlimited. And at least one court in describing it has said it is it's discretion of a judicial character that is exercised by the clerk in deciding whether or not to approve a bond. And that's a little bit unusual to have a clerk who's exercising what is something very similar to judicial discretion. They can be mandamus if they don't approve a bond that, at least on its face, is facially compliant. And they can also be mandamus for approving a bond that wasn't facially compliant with the rule. So basically what we came down to is kind of a list of maybe 6 or 7 options. And in terms of what Reagan's comment was, which was to always go to the trial court clerk to approve the bond, our committee really thought, you know, this is working in most cases right now, even with the clerk approving it. We shouldn't let the exception kind of make everybody have to go through this extra step that will burden trial court judges, and they don't need more on their plate. And it could slow down getting the bond approved. So we weren't enamored with that option, but kind of the alternatives are, oh, and the last alternative would be write into the rule something very similar to what the procedures are that the Harris County District Clerk's Office is currently doing, so that there's a very clear checklist of what is required for approval. So it makes it uniform across the state, because right now, some clerks like Harris County have these detailed guidelines. I checked with Bayer County through Judge Peoples, and they do not have written guidelines. They just refer to the rule and the statute. I assume that some of the smaller counties also do not have written guidelines. I did not check in Dallas. I would guess they are pretty on top of this. But kind of the options that we were looking at is, you know, leave the rule the way it is, which we just did on something else, because it's working in most cases, and that Reagan's cases are kind of the outliers. The second would be the Reagan Simpson idea, which is to require the trial court judge to approve the bond in all cases. A variation on that could be to give the litigant who is filing a supersedeas bond to, at its option, instead bypass the clerk and ask the judge to approve the bond. So that would be a variation on that. Fourth one is just to make the bond effective upon its filing, which filing, at least in my mind, is not just hitting the button to send, but the clerk also has to accept it, but not approve it, which is different. And then let the judgment creditor, if they're unhappy with the amount of the bond or the sureties on the bond, that they can, as they currently can do now, take it up before the trial court judge. We did have some concern with people filing junk bonds, okay? Not like junk bonds on the financial markets, but bonds that are not compliant. The sureties are crummy. It's, you know, Uncle Joe or whatever. just in order to stop execution, be able to move assets and do whatever. That's a risk we already have now to some extent with the net worth affidavit, I suppose with cash bonds. There is a provision in Rule 24 that does permit the judgment creditor to seek injunctive relief from the trial court in certain limited circumstances to prevent the judgment debtor from transferring assets to avoid execution other than in the ordinary course of business. So there is some remedy there. We debated whether there needed to be new sanctions to kind of guard against the idea of people filing junk bonds in order to avoid execution. And we were reluctant to add yet another sanctions rule when we certainly have plenty, and to invite ancillary or secondary litigation over sanctions in yet another context in our rules. So that is kind of, and the last option was to write all of the very specific things that need to be checked in order to approve the bond and continue to have the clerk actually engage in approving the bond. We had a great discussion, and we realized that this is a fairly major change in our practice. We did feel like it wasn't totally crazy because we do want, we felt uncomfortable, as some trial clerks do, with them exercising what is essentially judicial discretion. We wanted to see a uniform practice throughout the state if we could accomplish that. File and challenge is already in place in our bonding rules in terms of cash bonds and net worth affidavits. And, there is this injunctive relief, although that's fairly limited, and there are general sanctions rules available for junk bonds. So the rule we propose is on page 6. It's probably also on page 2, where we have changed subsection 2 to now read, instead of to be effective, a bond must be approved by the trial court clerk, to provide that a bond is effective upon filing. On motion of any party, the trial court will review the bond. That's what we got.
Thank you, Pam. Comments from people, thoughts? If you have any, raise your electronic hand. Sharina, yeah.
Sorry, did you say my name?
Yeah, we can hear you now.
Sorry. I fully agree. I've filed a lot of bonds and come into some of the situations that Reagan describes. I think it's an excellent change and I would be in favor.
Thank you. Roger.
I have nothing to add.
Take yourself off mute, Raj.
I thought I had. No, when they originally revamped all the supersedious rules about what you count, what you don't count, what you bond, what you don't bond, there was a lot of confusion. And bonds would be held up for 2-3 days while clerks would be calling me, calling the county attorney, et cetera, et cetera. Things calmed down, but still it may take a day or two. And in the meantime, if you've got a good bond, it means you're biting your nails, wondering whether they're going to be out seizing property, et cetera. So I think it's a healthy change. And if people think that the bond's bad or it's not the correct amount, that's what judges are for. So I think it's,
Thank you, Roger. Lisa.
I agree. I think the subcommittee and thank you, Pam, for letting me participate, even though I wasn't as good of a participant as I should have been. But I was watching it all, and I agree. Good appellate lawyers are going to confer with the other side if there's anything area of the law or any portion of the bond because we don't want to have to go get a bond a second time so we're having these conversations from the moment the judgment is signed and we may work it out or we may legitimately have disputes, but ultimately it needs to be filed. It needs to stop the execution of the judgment, and the onus should be on the other party to go get an order. The clerk should accept whatever is filed and then see what happens.
Okay, thanks, Lisa. Any other comments or thoughts? Richard Munzinger.
The draft of the rule says the court will review the bond. I think it ought to be mandatory, must review the bond promptly or something to that effect, because supersedious can have some very serious consequences, and a knowingly false supersedious bond or inadequate bond or one that cannot be cured can still cause havoc. And there ought to be some encouragement to the trial court to point out that A, you must address the sufficiency of the bond if it's questioned, and B, you got to do so quickly. That's all.
Thank you, Richard. Good point. Who else? Anybody else? Yeah, Robert.
I was going to also speak in support of the proposal. And also, I think Sharina had her hand up.
She's been recognized once. I don't know if she has it up again. I don't see it.
I'll be quick and echo what has been said. I think taking the clerk out of the approval process is a good decision. Most of the time, clerks aren't in a position to really know if it's a good bond or if it's junk. And I think if the parties have an issue after it's been filed, it's something that should be presented to the trial court judge to consider.
Great. Thanks, Sharina. Anybody else? Yeah, Professor Carlson. You have to take mute off, Elaine.
I'm so sorry. I'm on the subcommittee and I supported this change. There's a real uneven ability I have found in different clerks' office on being able to assess things like the sufficiency of the bond or even the law on what's compensatory damages. So I think you're weighing the rights of a judgment creditor against the judgment debtor, but a judgment creditor can seek a turnover order and even the appointment of a receiver, immediately after judgment. And it's vitally important to the defendant who's appealing that they be able to stop that. And I think the court already has the ability to enter sanctions if someone misuses the process. Thanks.
Thanks. I don't think you had joined us yet, but at the very beginning, Pam said that you are the most knowledgeable person about this issue of anybody in the state.
It's very sad, isn't it?
You mean we have minimum knowledge about this in the state? Justice Kelly. Peter, you're going to have to take your mute off.
There we are. An additional protection for judgment creditors in this situation is the Uniform Fraudulent Transfer of Assets Act, which gives a remedy in the trial court against the judgment debtor if they try to fraudulently hide assets. And so because there are several layers of protections for judgment creditors in this situation, I would support this change.
Thank you, Judge. Anybody else have any comments? Pam, it seems to me, for the first time perhaps in the history of this committee since I've been on it, we have a quick consensus about the work of the subcommittee. How do you feel about that?
Stunned.
Do you think we need further discussion?
No.
All right, thank you. We will submit this to the court for its review, and we will move on. And the next topic for us is Texas Rule of Appellate Procedure 34.5A. And let's see if you and Bill can top your last performance, Pam.
Well, I thought that was the hard one today, so I can only be disappointed. I can only be disappointed from here on out. This is item G, memo G. This is Rule 34.5A, and that governs what is automatically included in the clerk's record on appeal without designation by a party. And the court had communication from Ben Taylor, who asked that the court consider whether the supersedious bond, which is our subject of the afternoon, should automatically be included in the clerk's record and be added to that list. And the reasoning behind this is the appellant normally would not need to put the supersedious bond when it designates other items to be put in the record. On the other hand, the appellate court in a number of circumstances needs the bond in order to draft a judgment. So if the judgment of the trial court is affirmed and there's a supersedious bond in place, the judgment must render judgment against the sureties as well as the appellee, the party. So a clerk can't, or the court itself can't formulate the judgment without knowledge of who the sureties are so that they can render judgment against them. And the Supreme Court has a parallel provision when it's affirming a judgment either via the Court of Appeals judgment or the trial court judgment directly. And it can slow the process down. The appellee sometimes doesn't need to designate the record at all, so it adds additional expense to them. I did call upon Blake Hawthorne, who's clerk of the Supreme Court of Texas, and Michael Cruz, who's clerk of the Fourth Court of Appeals in San Antonio. They both supported the idea, thinking that it would be helpful in just streamlining it. It is very similar to other items that are automatically included in the clerk's record, like the bill of costs. Again, that's in there because the appellate court needs that in order to formulate the judgment and to assess costs against the parties as it sees fit under the rules. So what we would propose is on page 3 of your memo is adding new section 13 that adds as automatically included in the clerk's record on appeal in civil cases, any supersedious bond, and then renumbering the catch-all on whatever else the parties have designated as 14. A couple of people said, well, shouldn't we include any security document, like if there's a cash bond or whatever? The appellate courts don't need that to formulate the judgment because they only have to render judgment against the sureties. So if they are reversing a judgment, they actually don't release the judgment against the sureties explicitly in the judgment. They reverse the judgment, and under the terms of the bond, because it's conditional, the sureties are released. That's it.
Okay, thank you, Pam. Comments from anyone? Raise your mechanical hand. I see no hands raised. Now there's one. Professor Carlson. You got to take it off mute.
I know, it took me a minute to find the button. The only thing I would add is that there's no real concrete deadline to file appellate security. So ordinarily you want to do it obviously as soon as the judgment's signed. But you can run into a situation where the supersedious is filed after the record is filed. And I don't know if we want to require a party to notify the appellate court of that or not.
Mhm. Well, I think in that situation, we should just say, we can say any supersedious bond on file at the time the record is prepared. I
Well,
mean, we can't put the onus on the clerk to have to do it twice.
No. Didn't know if you wanted to have a party notify
Yeah.
a court, the appellate court. I don't know if it's that vitally important or not.
I think this will sweep up most
Yeah.
cases. And I guess the question is, in those few where somebody decides to file a supersedious bond after the record's been designated, they can just, I would just let them fix that later.
Yeah, okay.
Unless somebody else feels strongly that we have to be super precise.
Lisa,
No, I agree with Pam's position. This captures most of the bonds that are going to be filed, and the ones that aren't are in no worse condition than where we are today. And so let's let it fly.
makes sense. Anybody else? Okay, Pam, you may have set a Supreme Court Advisory Committee record for, okay, all right.
If I had a football, I'd be spiking it. Yep.
Getting 2 items through both unanimously and in record time. So having finished with that, we'll go to the next item, which again is yours, the briefing rules. And I don't know if you're going to do it or Bill or somebody else.
I have all the black beans for the afternoon.
All right, good.
Okay.
You're on a roll. Let's not slow it down.
I only wish. Okay. This was a referral from the court to examine certain of the briefing rules to see if they could be improved. And this was a task with 7 discrete subparts. So fasten your seatbelt, right?
Right.
And they cover kind of a broad range of things. I'd say the first four of them are more mechanical and 3 of them are more substantive in terms of what's actually the content of the brief. We have decided to take them in order of what we thought was easier to hardest. Because isn't that the way you want to do everything? So the first question is whether to remove the paper requirement, the paper copy requirement. Because right now the rule says if you electronically file a document in the Supreme Court and the Court of Criminal Appeals, within X days, you have to provide paper copies to the court, and the number of paper copies you have to provide to the court is determined by court order. And the Texas Supreme Court stopped requiring paper copies a long time ago. And the rule doesn't reflect that, and it confuses people who are not familiar with inside baseball. And so Blake Hawthorne, the court of the clerk, gets a number of calls of people or people trying to send him paper copies. So the Supreme Court pretty clearly wants it removed. And Blake agreed to contact the Court of Criminal Appeals clerk and start a dialogue with them to see what their druthers were. And at first they came back saying, we don't know, we need to think about it. But my latest information is they probably want to keep getting paper copies. So what we would need to do is just change the rule on paper copies to say you don't have to do it in the Supreme Court, but you still have to do it in the Court of Criminal Appeals. So that was I had originally set out 2 different options. One, if both courts wanted to stop getting paper copies, and one if just the Texas Supreme Court wanted to stop getting paper copies. And so option 1 is on page 2 to 3 of your memo. And what it says is we remove references to the Supreme Court in terms of where the paper copies go. And we add a sentence at the end saying a party need not file a paper copy of an electronically filed document in the Supreme Court. That's our proposal.
Okay. Comments?
This seems like, what's the comment, but.
Well, but we want to have due process here on this committee, so.
The court doesn't want them. We're going to say they don't have to take them.
The power is going to your head, Pam. I can see that. You want to ram these things through so you can do.
I'm ready. I'm ready now. Yeah.
All right.
Hey, Pam, I think I probably copied on communication, but you're saying that you did confirm with the Court of Criminal Appeals that they do still use the paper copies? Because I've only filed once with them, and it was kind of a pain in my latter years of my practice that I wasn't used to that, but they're still useful to the Court of Criminal Appeals.
I think some of them are still, yes, want the paper copies.
Okay.
Yes.
Okay, so no dissent. Pam, your role continues, although as you promised, it's going to get harder.
Yes. Okay. The second point is B on the bottom of page 3 of your memo. And it's whether to remove the requirement that makes mandatory inclusion of the Court of Appeals judgment in the appendix to the petition for review. And that is in 53.2K 1C. And if you've seen what courts of appeals issue, they issue an opinion, but there's a separate piece of paper that's the judgment. And a lot of even good practitioners, I think, when it says include the item says Court of Appeals opinion and judgment, a lot of times the only thing that will be included in the appendix is just the Court of Appeals opinion and not the separate piece of paper that's the judgment. And because it's mandatory, the clerk's office has to hold on to the petition and ask you to refile or provide the judgment before they can accept it as filed. So it slows things down. It doesn't affect the actual date of the filing of your petition. So your petition isn't going to be late or anything. I talked to Blake Hawthorne again about this, and what he indicated is all of these judgments are online. The staff attorneys say they're easy to get. They don't really need them. And it would just, from a pragmatic point of view, make everyone's lives easier if they didn't have to hold up these petitions to wait for people to refile with the judgment included in the mandatory appendix. Of course, you can always include anything you want in the appendix. There's optional, a provision that says optional, you can include whatever you want. There was some just sadness on our committee about this idea of foregoing including the judgment, because you don't appeal opinions, you appeal judgments. The court doesn't reverse opinions, it reverses or acts on judgments. And the judgment is really what our appellate life is all about. But pragmatism prevailed, and we did unanimously agree that the requirement should no longer be mandatory, especially in the world. Hopefully at some point we'll be moving to, you don't have to include any of this because it'll all be electronically forwarded to the court. So what we would suggest is 3/4 of the way, or almost at the bottom of page 4, is to change 53.2K C, capital C, to no longer say the opinion and judgment of the Court of Appeals, but to say the opinion of the Court of Appeals as a mandatory item to be included in the appendix to the petition for review only.
Okay, they're lined up to get you now, Pam. Lisa.
I'm not going to get her. I get where she's going. I actually have had a petition for review dinged when I did not include the judgment inadvertently. So I'll just say that as a board certified lawyer or appellate lawyer. But what I like about requiring the judgment is it does keep us focused on the court's role. And much like there's some purity to wanting final judgments that mean something being snail mailed to people because they realize this is the important thing. In much the same way, I think that judgment of the Court of Appeals needs to be forefront in our minds. And I'm embarrassed when I forget to include it. In those rare times I forget to include it, I'm mostly embarrassed and I get it to them like within 15 minutes. But I think there might be other people who are petitioning to the Supreme Court who really haven't thought about it or even looked at the judgment of the Court of Appeals. And we have seen significant cases that depend on the wording of the judgment instead of the wording of the opinion and what to do when there's conflicts about them. And so just as an appellate purist, I would not support the subcommittees, even though if the court wants to do that, I am on board with how the subcommittee has solved the problem, but I just want to go on
to the court, Lisa. Come on.
I just want to go on record, like we need everybody to keep focused on the judgment. That's what we're reviewing.
Got it. Kenan.
It's a related comment. If it's the judgment that's being reviewed, why not remove the opinion and keep the judgment? It just strikes me that the opinion is almost always more voluminous. It's taking up digital space. It's not what's being appealed. It is equally accessible online. So I'm struggling to understand why we took out the judgment and kept the opinion.
Nina's going to tell us the answer to that.
Well, I do think you need both. I mean, obviously, how the Court of Appeals reached its conclusion is very important to the Texas Supreme Court in determining whether review is appropriate. So I think the opinion comes in, but I also think the judgment should come in. And like everyone else, I would say I've done it too, forgotten it, got thrown out, had to refile. But it's important to stay focused on the judgment. And if people aren't, then they're not. Sometimes actually there's problems in the judgment. It's not in accord with the opinion. It awards relief in a different way. So I think it's important to keep practitioners aware of a very key document. And then of course, all the things you've already heard, which is it is the judgment you are appealing. But I think beyond that, I don't think it's just an issue of appellate purity. I think it's an important document that everybody needs to be aware of as part of the process. And if we don't, then we are losing sort of a tickler, if you will, for all practitioners, not just appellate, specialists, but all practitioners need to be reminded, this is the key document. You need to know about it. This is what this Texas Supreme Court is going to be looking at, as well as the opinion. So it warrants being attached. So I would keep it in.
Okay. Roger.
Well, yeah, I just want to echo that. Initially, when I read this, I thought, well, why do we need the judgment anymore? But several years ago, I read an article about the importance of the drafting of the judgment, especially as it pertains to the scope of remand, et cetera, et cetera, et cetera. And how sometimes there can be a conflict between the opinion and the judgment over what's going back if they're not synced properly. So I would add the point that it not only helps the appellate practitioner remember, it helps the person who wrote the judgment in the first place to think that this is not an afterthought. And it encourages both the author and the reader to think a lot about what the judgment says. Leaving it out would be a subtle communication that this is not an important document either to write or to read. So that's my 2 cents.
Okay, thanks, Roger. Any other comments, Pam?
Well, I like to make clerks' offices happy because they're the people you deal with every day. So I would be inclined, because it has been a pain for them to have to review and bounce all of these, to let them do it. But if the will of the committee is to leave it in, just to remind people of the importance of the judgment, that the justices could certainly tell the clerks, from this day forward, we will not bounce petitions just because the judgment's not there.
Evan Young.
I share a lot of the concerns, and Pam, I guess I was sufficiently vociferous about it that Pam credited me in the memo with that. I would just comment that at the U.S. Supreme Court, which is at least as assiduous about all of the technicalities and formalities and all the rest of it, a cert petition's appendix must include the judgment sought to be reviewed if the date of its entry is different from the date of the opinion or order required in a different subparagraph of the opinion that is accompanying the judgment. So it's just interesting. Of course, that court also, it's reviewing judgments, not opinions. That's the mantra, and the justices of that court are very fond of quoting it. But that court doesn't require judgments unless it's of a different date. That's for a different reason to compute whether or not it's jurisdictionally out of time, given the relevant statute. So given Pam's referral to us of how the clerk's office says we don't need this, it's a real burden on us, I would agree. I kind of like keeping it in just for all those salutary reasons that are articulated, but it's, these are to benefit the court, not really to benefit, the appellate lawyer who should know to look at the judgment. And with that, it strikes me as a possible way of either doing what Pam mentioned, which is to say, well, we just won't bounce it if it fails to comply with this rule, but we'll leave it in the rule in order to be able to signal the importance of the actual operative document, or take it out just on the grounds that if it's that the appendix is there to benefit the court, and the court already has it and doesn't need it, then that would be the message hopefully that would be conveyed, and not the message that the judgment actually isn't significant.
Yep. Thanks, Evan. Yeah, Pam, on the issue of blame, why don't we just tell Blake that it's all Jackie's fault, or whoever the rules attorney is at the time? She
wouldn't be happy with that.
Probably not. Okay, any other comments? We're about to take a vote. Everybody who wants to take it out, which is the subcommittee proposal, raise your electronic hand. Everybody voted who wants to vote? I count 13.
I count 14.
All right. Let me look again. 4, 5, 6, 7, 8, 9, 10, 12, 13. Yep. Okay. 14. All those who want to leave it in, raise your electronic hand.
People have to lower their hands too if they.
Yeah, lower your previous vote hand and don't vote twice. And
Pauline, can't you lower the hands for everybody after a vote?
Yes, but they already started voting, so I can't determine who didn't lower their hands.
we're going to trust them. So there's how many did you get on this vote, Pauline? Yeah, you're muted, so you'd have to.
12.
Yeah, that's what I got. So 13 take it out, 12 leave it in. So much for consensus, Pam. Your streak is over.
If you told me that we would have done that on this item compared to completely changing approval of supersedeas bonds, I'm still stunned, so. All
Okay.
right.
All right, well, a stunning result, but nevertheless, go on to the next item and we'll be the judge as to whether it's difficult or not.
Okay. This is the hardest conceptually for most people because it involves how the electronic filing system works. And Frank gave us a good preview of that today and also how case management works. But the question is whether to maintain a certificate of service requirement for e-filed documents in appellate courts. If you have not looked at a recent document filed in the Texas Supreme Court, it's worth doing that because in the e-filing system, the individual court can turn on a switch that says produce an automatic certificate of service. And that then appends to the back of the document and it shows exactly who was served through the e-filing system. And it doesn't matter what your certificate of service says, and many of them are wrong, or at least that's been my experience as somebody who doesn't get service or who hits the button to serve and it includes 50 people I didn't list on my certificate of service. The only way to know accurately who is served through the e-filing system is through the e-filing system report that's generated and then attached to the back of the document. And on page 5 of your memo, it shows all of the courts that have turned on this automatic certificate of service. It includes both the highest courts of the state and all but 3 of our courts of appeals. And those are the only courts we're talking about right now. The 2nd, 10th, and 12th courts of appeals, High Justice Gray, Chief Justice Gray, have not yet opted to turn it on, but my understanding is that Blake Hawthorne and the OCA Office of Court Administration is doing their best to persuade all the courts in the state to move in this direction. And I have exchanged some emails with Blake Hawthorne, clerk of the Texas Supreme Court. I've set out his comments. He thinks this works great. It's really the best way to know. The 2 issues I saw with this are one, obviously we're going to have to maintain the certificate of service requirement for parties that do not file through the e-filing system. So you do get pro se or indigent parties or whatever who are still filing paper copies with a court and not filing and serving through the e-filing system. The second is there are documents that are required to be filed in the appellate rules that actually are not filed in the appellate court. So your supersedeas bond is filed with the trial court clerk. Your notice of appeal, a few other documents are just not filed in the appellate courts. So what we have done, and the subcommittee eventually saw their way to this. We had some struggles along the way, but we unanimously recommend what you see on the top of page 6. And what we've done is documents that are served electronically. You can't serve a document electronically unless you filed electronically. So it's also going to have been filed electronically. It says a proof of service and a certificate of service are not required for a document filed electronically. And then we add in an appellate court. So we're not covering documents that are filed in trial courts that may or may not have turned on the automatic certificate of service and are also served electronically. And then we have documents not served electronically. And there we have done a little bit of renumbering, a little bit of tinkering to add subsections that basically take the paper certificate of service that you used to file and limit it only to documents that are not served electronically.
Okay, Justice Gray had his hand up before you got your third word out, Pam.
I imagine so.
And he doesn't want us to hear him because he's muted. Nope, you're still muted.
I was trying to use the space bar as Robert recommended, and for some reason that feature wasn't working at the moment. Well, see,
Thanks
first of
anyway,
all,
Robert.
I was trying to work with the Fourth Court of Appeals to make it where we were the Dr. Pepper courts, the 10, 2, and 4 that were not doing this. When Blake approached me on this, I told him that we would do it as soon as we got a rule on it. So I'm in favor of the rule because I don't want to do it, but right now the rule does not provide certificate of service. And so I try to play by the rules. So I'm in favor of it for that reason. Do it. And I'll let it go at that.
Thanks, Judge. Anybody else?
Hey, I'm in favor of the rule, but I do want to correct something that Pam said that I think was innocuous and not, but you actually can file and or serve separately through the system without doing both. So I can serve discovery on somebody where I don't file something, and I can file something where if I'm a shit, which I'm not, but I could not actually serve something I file, but the two screens are separate and you actually can do those separately on the system. But it's irrelevant to this conversation because what the screenshot will capture is who was served, which is what we're talking about, regardless of, like, it will capture everybody who is served.
Great. I did not understand that, and I appreciate the correction.
She's board certified, you know.
Aren't we all?
No, we're not all board certified. All right, any other comments? Yeah, Kenan.
It's 2 points, and they're kind of side notes. I'll be quick. First point is I continue to think that we need amendments to the Texas Rules of Civil Procedure to state more precisely the manner of service comparable to the rules we have in the appellate realm. The second point is that something about the certificate of service and how it's structured has always bothered me a bit, because you put it in your document before you file it, and you state you have served a document before you have served it. And I struggle with that because it's a representation that is on its face inaccurate. It hasn't happened yet. So I raise that just because I have myself at times put into certificates of service, the document will be served in X way because that feels more accurate to me. And I may be splitting hairs, but this is something that's always just kind of troubled me a bit because the attorneys are making representations that aren't in fact true when they're being made.
Plus, they don't serve them themselves, so they don't really know.
Right. But in the old days, Kenan, your assistant, your legal assistant would frequently send out the service copies at or before the time that the runner went down to the courthouse to file it.
And I think it made sense to structure the certificate of service as stated when that happened, because the service, maybe had occurred beforehand, but now you make that representation all the time before you've actually served. And then you encounter sometimes difficulties with effectuating service as intended. You've already made a representation in a filed document with the court. And it just raises some kind of unnecessary dilemmas, I think, in the mind of the attorney trying to be as honest as possible.
Got it. Thank you. Robert.
I agree with Ken. The statement or the practice of certifying service is anachronistic when we have electronic filing. And not only is the timing off, but you're trusting that the electronic system is doing what it's supposed to do. And you don't really know. You don't know if opposing counsel gets it. System's designed to accomplish that, but the whole purpose of certifying service of process, I don't think really should be in there.
You do know that they got it because you can go into the e-filing system after you serve a document and it shows who opened the document and who received it.
You can do that later, but you don't know it while you're doing it. Plus, it's not your, your action, it's a system.
You do know while you're doing it because you put a check mark next to everybody in the list of council who you are serving. So you have, and those are the people who are going to get served. It's extremely accurate. I think I've had cases where I think people affirmatively uncheck my name, which I don't quite understand the reason for that. When I represent an amicus, they don't have to serve me. And so they decide they're just not going to, but that's a whole different issue. But no, you know who you're serving through the East. I file my own documents, so I know how these work.
Well, don't you also get notification of filing even if you're not checked for service in those cases, if you're a listed counsel?
No.
Lisa.
I think, I think Kenan and Robert have raised a good point, but I think they're actually in favor of the rule change, right? Because we're now not just like certifying that the lawyers are doing what they're supposed to do, but we're actually getting a third-party confirmation that they did in fact do that thing. So, I mean, I think this is great. I mean, I'm probably going to be one of those old school like dinosaurs who still keep my certificate of service, and that's just tacked on to the end as it is with my Supreme Court filings right now. But maybe, 10 years from now, some associate's going to be like, why are you so old school? And I'll change it. But right now, I believe the most accurate formation of who was actually served is from that third party server that says these parties were actually served. And I don't think there's better evidence of who was actually served than that certificate that the clerk's office gets.
Okay, any more comments about this?
I should have stated, I agree with the rule instead of just stating things that weren't really on point in regard to the proposal. I do agree with the proposal.
Yeah, that occurred to me, Kenan, but we're moving on. Okay, hyperlinking. This is easy.
If you've ever had to make your own hyperlinks, it's not easy. But the question is whether or not we should move to a uniform system of citation. Am I frozen?
No.
Okay. Uniform system of citation to the appellate record in the appellate courts so that they can automatically hyperlink to the appellate record. And if you're not familiar with, appellate courts now currently have a system in Texas where they do automatically hyperlink to the cases that are cited. If they are online, they can, click on the case and it will, I think, pull it up in Westlaw or whatever. The Fifth Circuit has a program that automatically hyperlinks to the record. They have a uniform system. It's ROA and then the page number. In the Fifth Circuit, the appellate record is one document. It's consecutively numbered. So it's pretty easy to figure out how to connect that site to that record in that case. I've had a number of conversations with Blake Hawthorne, clerk of the Supreme Court, on why the Fifth Circuit system currently cannot work in Texas. And I think you heard earlier from Shireen that all of the clerks and counties and district courts have different case management systems. Some are Mercedes and some are Hondas. And our records are produced a little bit differently. They're produced by individual clerks from 256 counties across the state. So they're semi-uniform, they're not super uniform. We have a separate reporter's record that's not consecutively numbered with the clerk's record. And as Blake explained it to me, he dumbed it down for me. He said, think of it as like car parts. In the Fifth Circuit, all the car parts are standardized. So if you need a muffler, everybody uses the same muffler. In Texas, we have basically every kind of car you can name. And so we can't develop a program at this point that plugs that muffler into an automatic hyperlinking system. Obviously, this is something that they are striving or desire to get to at some point in the future, but right now it's not technically feasible in Texas. The question is whether we want to develop a uniform system of citation just to get used to it right now. I'm not sure that the appellate courts are too burdened by not having a uniform system. Most people use one of 2 or 3 different formulations. You might, for the reporter's record, you might put 1 RR and then the page number, and for the clerk's record, you put 2 CR and the page number. And then of course we have first supplemental and second supplemental and third supplemental clerk's records, but that's another story. And you develop just some kind of thing that works. And I don't know that appellate courts and staff are having that much trouble interpreting the citations to the record at this point. What I would say, and we could do it, we might have to change it later if the technology becomes available with a uniform ability to hyperlink to the record. We'd probably have to completely change what that citation to the record would be. That would really not accomplish the ability to hyperlink in any way. And I guess in terms of, we do have a lot of appellate practitioners on this call. We are very protective of our word count limit. And we would be vigorously opposed to anything that would add any extra spaces in the citation form so that 1 CR3 suddenly becomes 3 words instead of 1 word on our word count. But our committee unanimously agreed to propose no change at this time and to encourage OCA and the Joint Committee on Information or Technology, whatever it is, to pursue exploring how we can have a uniform record so that we can get to this at some point in the future.
Okay. Are there any proponents to change now? I know the subcommittee unanimously rejected that, but how about somebody like Justice Gray who wants to change now?
You will maybe find this surprising, but I do like technology. I would really like to see this happen sooner rather than later. And I think that the way to do it is from the top, meaning that if the Supreme Court will impose the rules that make it the most efficient and economical way to do it, the courts of appeals will follow, then the trial courts will follow, and we will be there much, much sooner than waiting for JCIT to try to implement it from the ground up. This is one of those things where I strongly recommend to the Supreme Court to lead where the rest of us can follow. If they don't do it first, there will be I think Pam said there's 3 or 4 different methods generally used in citations now. She must work with just 3 or 4 different appellants or appellees because they're all done different ways. And in the criminal arena, where there's a lot more, let me say, there's a lot fewer appellate specialists, we see a much wider range of kind of ways to cite things. I just think if the Supreme Court takes the bull by the horns, cram down effect, we will get there sooner.
Thanks, Justice Gray. Lisa.
Yeah, I want to reiterate 2 points. One, Pam has already spoken on behalf of all of us who are appellate practitioners of there should be no spaces in any of those record citations because that takes away our word count. We do not want it. It needs to just be all one. How awkward you make it, capital letters, I don't care, but no spaces because I want one word for every record citation. But to Justice Gray's point, which is actually really important, you know, those of us who practice mostly in the Supreme Court, we have the benefit of, at that point, a mostly stagnant record. But I can't tell you, I mean, I commiserate with Justice Gray about when I am in the Court of Appeals, I'll be writing my brief and I'll realize either something I requested wasn't included in it or something I didn't even know existed was not included. But either way, you get these supplemental records and no clerk's of the 254 clerks' offices. Some will call it first supplemental record. Some will call it supplemental record. Some will, but the names get a little bit lost. So I think that's going to be the challenge. And because the Supreme Court has so many more stagnant records, it's very rare that I supplement at the Supreme Court level. I think y'all may be able to look at your database and kind of assess the scope of those names in a way that would be hard among the 14 Court of Appeals.
Okay, so the thanks, Lisa. The recommendation is to wait for the technology. Justice Gray says, come on, court, be a leader, don't be a follower. But is there anybody else that wants to speak up in favor of we need to get a rule, we need to spend some time to get a rule before the court to speed up the technology? Okay. Anybody feel strongly about it? Jackie, I think we'll leave it to you and Martha and the court to tell us whether you want us to work on a specific rule. Because right now we're just saying, you know, wait for the technology.
I'll get some feedback and get back to you.
That'd be perfect. Thank you very much. Let's move on to whether to remove or limit the statement of jurisdiction.
Okay, this is item E on page 7. Right now, statement of jurisdiction is mandatory in both the petition for review and petitioner's brief on the merits. And it's supposed to state without argument the basis of the court's jurisdiction. The court's jurisdiction used to be a little more complicated than it is now. There used to be a lot of subsections like dissent, conflict, cases involving state revenues or the Railroad Commission. And these were all amended in 2017. And basically, it's a one-stop shop. Is the issue presented important to the jurisprudence of the state? And the interlocutory appeal statute was similarly amended so that it now falls under that same jurisdictional umbrella. So there's really not much on a normal petition to dispute about jurisdiction other than whether the issue is important. People like me, though, view this because the statement of jurisdiction is not included in the word count. We'd beef it up. It's like the free space in bingo. You go for it right there. I can understand that the court probably skips that most of the time now because jurisdiction is really, do they think it's important and are there enough votes to grant? And so we kind of came down with, you don't need it. And so take it out in both and also take out in the response to petition and respondent's brief on the merits, the reference to the statement of jurisdiction. And that recommendation is on page 8, just above F.
Thank you. Comments about this, eliminating the statement of jurisdiction? Nina?
It's really more in the way of a question. I understand, and I'm kind of neutral on this, but do you think that for those who don't regularly practice in the Texas Supreme Court, whether there isn't a purpose to be served here by making sure that that person or that lawyer understands the way to frame the petition is to fall within this jurisdictional standard? So it's really not for this group that's here today, but for those who are less frequent visitors to the court, whether it isn't important to remind them of the standard that they need to address, because if they miss it, then their entire petition could be wrong-headed.
Thanks. Mike Hatchell. Take yourself off mute. And if you don't...
Sorry about that. Now, I think it's useful to state the basis of jurisdiction. I'm not sure that even though we've had an amendment to our jurisdiction to eliminate subcategories, I'm not sure that all categories are the same, such as original proceedings may have a different statutory and constitutional basis. And there also is 2 or 3 unwritten grounds of jurisdiction. One would be Eichelberger versus Eichelberger, which is of a constitutional dimension. And then there's the hidden appeal from courts of appeals that I won't go into. But since it's so short and there are varying reasons or varying bases for jurisdiction, I don't see any reason to take it out. I think it's very useful to have.
Thanks, Roger. There you
I
go.
was going to say that maybe Mike can address this, whether there were any oddball statutes of providing jurisdiction aside from that in the government code, such as direct appeals from the trial court, like some federal jurisdictions or not. It might, so that if there were, shall we say, something in addition to the general basis, it might be worth a section so that the party could alert the court to an additional basis. That's all.
Thank you. Lisa, next.
Yeah, so I think but what Hatchell and Roger are getting at is what would be the basis for the Supreme Court to, on their own right, if there is an unusual basis for jurisdiction, which would not be the traditional petition for review or even the petition for writ of mandamus, what would be their grounds if they doubted jurisdiction? Would the party be thrown out, or would the court have some means to do it? And I think, you know, the short answer is that historically the Supreme Court has questioned its jurisdiction, particularly on direct appeals. Anytime you bypass the Supreme Court and you allege some basis for it, they've requested a briefing purely on the jurisdictional issue. And Pam is raising her hand, and so I'm going to defer to my esteemed colleague that she may know more than that. But that's kind of my concern is I generally think that section is useless in 99% of filings, but in the 1% that it is useful, then I do worry a little bit about it, along with Mike and Roger.
Pam.
Well, I think the 1% fall under different rules. So if you are filing for mandamus, that's a different rule. It does require a statement of jurisdiction. If you are bringing a direct appeal, that's a different rule. You file with the court, you know, a document asking them to accept jurisdiction over the direct appeal, and the parties brief the basis for jurisdiction in all of those cases before the court requests or accepts the case and requests briefing. So we're not talking about the 1% of cases. We're talking about the 99% plain vanilla petition for review cases that are not under some extraordinary chutes and ladders way to the court.
So you're excluding, you're just doing the petition for review rule and not the petition for writ of mandamus. So if I have a mandamus against executive officer, I would still need to explain why the court could mandamus an executive officer.
Yes.
Okay.
Just in the petition.
Okay, Scott.
Thanks, Chip. I'm on that subcommittee and I agree with the recommendation to drop the statement of jurisdiction. I will say though, as an alternative, if the court decides it still wants to have that section in, I think we all agree that we find that that section gets misused more often than not. It's turned into another argument section. So the alternative I would suggest is at least putting a very small word limit on that section if it's kept, maybe 50 words, something like that, and not apply that toward the 4,500 word limit. But I think we've got to rein in these crazy long statements of jurisdiction that have just become another argument section.
Yeah, Pam.
I love it. I love the statement of jurisdiction section.
Yeah, okay. So the subcommittee says take it out. How many are in favor of take it out? Put up your electronic hands and be counted. Everybody done? Pauline, how many do you get?
14, well, 15 now. Someone else just voted.
Okay. Okay, 15, take it out. How many for leave it in? Everybody lower your hand. Everybody lowers your hand and now leave it in.
Mine's still up.
Well, take it down.
Okay, I did.
Everybody done voting? I got 8. Pauline, how many do you have?
8.
Okay, 15 to 8. Take it out. All right. On to the next item. Whether to add a reasons to grant section in the petition and brief. Are these words going to count, Pam, or not?
Yes.
Uh-oh.
Reluctantly. To begin with, I guess I want to say our subcommittee believe that the petition and brief serve fundamentally different purposes. And I know that Evan Young on our subcommittee has been working with the court to examine the petition for review brief on the merits 2-stage process to see whether adjustments to that to parallel more the US Supreme Court are in order. But the concept in the US Supreme Court is that the petition is to convince the court to grant review, and the purpose of the merits brief is to actually brief the merits. And under our current system, you sort of have to make your pitch in both. But for purposes of examining changes going forward, we as a subcommittee thought it's best to recognize, at least in theory, that they do serve different functions. And so we did think that the idea of including reasons to grant in the petition for review was a great idea. We did not think it was such a great idea at the merits briefing stage, where you're supposed to be briefing the merits and not trying to sell the product anymore. So the rationale was a lot of good practitioners are already doing this. Many either do it in the introduction section or in the statement of jurisdiction section or in the summary of argument. They are addressing court, here are the reasons, the issues here are important to the jurisprudence of the state and why the petition should be granted. And a number of us already do, summary of the argument, review is warranted, or, introduction. This case presents issues important to the jurisprudence of the state. And so adding this section is a way to try and up everybody's practice so that everyone's doing that. And we kind of discussed where and how it should go, whether it should be up front. And also, of course, vigorous discussion of how it would affect our ever protected word count limit. And what we did decide was, right now in the petition, if you include something that's like introduction that explains why the court should grant review, the summary of the argument is not super useful as a separate matter. In fact, summary of argument is required in the petition. And sometimes if you're not actually arguing about reasons to grant, there's not much to say in there other than 2 sentences about everything you already are going to say in the next 4 pages. So it can be very, very redundant. So in terms of trading off on word count, we're willing to leave the 4,500 word count on the petition by substituting a introduction and reasons to grant section and deleting the summary of the argument on the theory that that's kind of a wash in terms of words. And our recommendation would be to put the introduction and reasons to grant section before this, right after the issue statement, but before the statement of facts, so that it would front end load the petition and the court could see right up front why you think this case merits their attention and agreement. So our recommendation, unanimous again, is on, it got a little complicated, let's see, is on page 10. So you can see in C, excuse me, I've had to talk way more than I've talked in the last 6 months, I'll tell you that. We have taken out section E, which was statement of jurisdiction in accordance with our last discussion, and renumbered issues, relettered issues presented. We've added new section F, introduction and statement of reasons to grant. And it says the petition must contain an introduction stating the reasons the court should grant review. Then we have modified H and say that if you want a summary argument, you can have it, it's optional. And then instead of calling the argument, we are calling it reasons to grant, again, to help whoever is writing the petition to focus on what the purpose of the document is. And I think that covers it. And we did need to change the response to petition rule, which is right above G on page 11, where we give the respondent the ability to include a statement of the reasons the court shouldn't grant review, which of course is what the whole purpose of the response to the petition should be, and not always is. And then we also determined or agreed that no parallel changes should be made to the briefing on the merits rule.
Pam, just the summary of your recommendations are at the top of page 9, right?
Probably. Yes.
Okay. And then the actual language is on 10 and 11.
Yes.
Great. All right. Comment. Nina.
I agree with everything that has been recommended. I would suggest one slight modification, and that is the header on subsection I. I would stay with argument. I think it's a little confusing because, as suggested, because you have statement of reasons to grant in F, and then we've got reasons to grant again down in I. I think argument is really what we're talking about here, and often, at least how I've always done it, I have to say, I've always done a reasons to grant section, so I've done that. But the argument, it can be a little bit different, and I think you make the point you want to make in the body, where it says the argument should state the reasons why the court should exercise jurisdiction. So there's not confusion there. So I would stay with the original header.
I'm fine with that. It would be subject to, I think this came from Evan Young in terms of changing that word. And Evan, are you okay with that?
Well, it's not so much whether I'm okay with it, whether the court thinks it's useful. To me, honestly, the petition, this is the distinction between the brief and the petition, what we would maybe characterize as argument might really just be a subset of the reasons to grant, if you accept the premise that the petition is there, the document to cause the court to say, all right, we have a limited docket, why this case should be included for plenary review on that plenary docket among the many, many cases that we get. One basis is, the judgment below is wrong, or the opinion below is wrong, even, I suppose we could say, based on our prior discussion. The others would be things like there's massive confusion, or the case is really important. This relates to the jurisdictional issue. The case is just really important to the state. It involves a lot of governmental entities across the state. It will affect a lot of money across, whatever those things are. Those are reasons to take it that are not primarily about the merits, but one of them also just is, this is an error in the law and you should fix it before it metastasizes beyond what already has happened. And to me, all of those we signal. I think, Nina, maybe you had mentioned at least once today, what are we doing that signals to people what this is for? And I think that deleting the word argument helps people at the petition stage understand that everything I'm saying, yes, it's an argument, and we can be clear whether in the text or in guidance, but it's an argument that's focused not primarily just on the lower court got it wrong, but it would include that. And I don't think it's important that it matches up with what the US Supreme Court does just because the US Supreme Court does it, but they have been fairly successful in their certiorari process of not having an argument section at all, but calling it the reasons section, as this would do. And I think it really does make all practitioners, whether they're routinely in the US Supreme Court or not, stop and recognize the distinction between an ordinary argument you make to an appellate court about why you're right versus something that's a little bit more nuanced and more useful to a court with discretionary review. So I personally would prefer to keep it this way, but it wouldn't be the end of the world. It'd still be a great advance, I think, to make these other changes.
Lisa.
Okay, so I kind of think I'm opposed to even the fundamental changes to the subcommittee recommendation without making Pam mad at me that I didn't say that before, because she was kind enough to include me on a lot of correspondence with the subcommittee.
Yeah, statute of limitations is passed, Lisa.
Okay. And here's the reason why. This is all an art form, and the petition is especially an art form. Okay, like where we add value as appellate lawyers is at its height at the petition stage, I think, but we carried on through the briefing. Obviously, we're all really concerned about the development of the law. But I'm telling you, even though I appreciate, as I read what's supposed to be in my petition for review, I have never done a summary of an argument. I have always said reasons why the petition should be granted if I'm petitioner, or reasons to decline review if I'm the respondent. And never once has my brief been stricken for doing so, which is all to say, sure, it's good to, like, those of us who practice in the Supreme Court all the time, we know that that's our job. We're either trying to convince the court to take the case or try to convince the court to let it go. But what you put on those headings is so not important and has never been stricken, at least in my experience, even when I didn't completely comply with it. Because really what they're looking for is they want the art and not the, and some people have it, and Pam, you have it, and Nina has it, and Evan has it. And you guys all have it, whether you're on the petitioner side or the respondent side, but changing those headings, it's sort of, you're just, I feel like it's missing the point, in my opinion. And it's not helpful. And I'm not sure that, and I hear the argument that it might make other people who are not us in our little appellate world, think about it more, but they probably also won't do as good of a, like, it won't really change the summary of the argument or it'll still be a summary of the argument. Like if you don't get the art, you don't get the art. And, I don't know. I just feel like I'm not opposed to any of this. It's what I do anyway, but I also don't think it's necessary, whether you call it a summary of the argument or reasons to grant review. It's never been deemed either way. And so I don't know. That's just my kind of opinion. Sorry.
Sounds like you feel strongly both ways. Hatchell.
I'm for the change. I think most summaries of arguments these days at the petition stage are crammed into whatever few words you have left and are largely meaningless. I mean, they just become abstract statements. And I think the change would perhaps channel the non-specialists into thinking more creatively about the underlying policies, values, and adverse consequences involved in the case. My only change would be, which is what I do in petitions now, is I would make it much earlier on. I would make it virtually the first thing you read when you turn the cover of the brief. And I mean, most people know I absolutely detest what Brian Garner has called these visually repulsive statements, single space statements of the case, which I don't think anybody reads. So I think you ought to engage the court very early on what this case is about from a fundamental level by moving the reasons to grant forward.
Okay, thanks, Mike. So we have recommendations from the subcommittee.
Can I just say something
Lisa
in
wants the
response to
last
that?
word, though. Go ahead.
I'm
Lisa.
sorry, but never in my life have I thought that the contents of the petition for review had to be in that order. So there are times that I go heavy on the front end because, again, it's an art where I want to set the stage before you read the statement of facts. There's other times that the statement of facts lead to my legal argument. And so I want the state, but there's nothing in 53.2 that says this is the order. And I've never read it as such. But I mean, I respect my appellate colleagues if they tell me I'm wrong on that, but I've never read that rule to say there is an order. So are we really talking about requiring an order to those?
No.
That's not the way I read it either. Justice Gray.
The petition for review must, under appropriate headings and in the order here indicated, contain the following items.
Well, that's always been viewed as just a guideline, not a code.
Well, we're all doing it wrong. We've got recommendation and we've had a nice discussion. How many people are in favor of the subcommittee's recommendation? Electronically raise your hand. Pauline, I've got 18.
I have 19.
Okay, maybe I missed one at the end there. 1, 2, 3, 7.
It's like 21.
Yeah. 21. All right. Those opposed to the recommendation, everybody put their hands down.
Oh, wait.
Or Pauline, you could put everybody's hands down. Okay, now everybody opposed to the subcommittee? Anybody else want to vote? So by a vote of 21 in favor, 2 against, that'll give the court some sense of our subcommittee or our committee's recommendation on that. Okay, we're on to G, the home stretch here, Pam.
Well, except that we have a whole nother agenda item, but yes.
Well, I know that, but on this agenda item.
Yes, okay, this is whether to add a requirement to include a citation to where the argument has been preserved. And we viewed this as a question limited to Supreme Court petition and brief, and it's not that simple to say exactly where in the record the issue was preserved, because it depends on a lot of things. It depends on whose burden it was at trial, whether it's a JNOV, whether you were appellant or appellee in the Court of Appeals, whether the error arose at the trial court, in the Court of Appeals. And sometimes you have no obligation to have preserved error. And it takes a lot of time and space to explain all of those factors. And again, we are zealously guarding our word count. It didn't seem all that useful in most cases, because in most cases, by the time you get to the Supreme Court, you're not really often fighting about whether the issue has been preserved. Usually it will have been addressed by the Court of Appeals, so you know it's been preserved at that point. And the Supreme Court, even in those cases where parties do challenge and dispute whether an issue has been preserved, takes a very liberal approach to preservation and generally does find that it has been. So it would be using a lot of time, effort, energy, and words to provide information that in most cases is not necessary. And in those cases right now where preservation is an issue, the respondent is always free, and in fact, maybe under the obligation, as is probably the petitioner's counsel, to show that it has not been. So we generally thought this was not a great idea. We would leave it as it is. If the court for some reason thinks it's that important to require this in all cases when it's only going to be an issue in a very small number, we would recommend that it have to be done on the issues page that doesn't count in the word count.
Pam, you must have thought that this was going to be the most difficult issue of all of these, A through.
No, this just kind of fell into the substantive changes, so that's where it ended. No, I thought the supersedious one was going to be the worst.
Okay, Lisa.
Well, I want the record to reflect that I completely agreed with the supersedious thing. Hey, Jackie, I just have a question. Was this proposed, because as I understand it, and maybe around the time I was at the court or around the time I left the court, the law clerks have to do this section in their memo. And so the idea would be to create a section in the brief where it kind of centers the law clerk so that they don't have to go through the record, you know, so difficultly, that both parties have addressed kind of whether this was preserved and where it was preserved in a way that helps them do their study memo. Is that kind of the thought behind this recommendation? Or
I honestly can't remember off the top of my head exactly where the recommendation came from. Martha, do you?
Yes. This, I think, came many years ago from the Court Rules Committee, the State Bar Committee. And it was kind of championed by a staff attorney at an intermediate court of appeals. And this was back when I was the rules attorney. And the impression that I got from being present at the meetings where that was discussed was that they have such a high volume of appeals that they have to go through. And I guess in some cases there are people making, trying to make arguments for the first time on appeal that weren't preserved, and that it adds to, her time, or it becomes burdensome on the Court of Appeals staff to have to go through and kind of weed through the record to try and find, to see if the argument was preserved. I agree with the comments that this, I don't think, is really an issue in our court, just because of the nature of the practice. So
it also, I'm sorry, it also encourages, once you start down this road, more fights about preservation once you start having to put it in there.
Yeah, if there's a serious preservation issue, your opponent is going to point it out. The respondent is going to point it out. So, Roger.
Yeah, well, I'd like to sort of argue the other side, because I remember when we used to do points of error, and the rules of procedure or required that the point of error contain a reference where the error was preserved in the record. And I think that was useful because it focused people on what was the error, not what your legal argument is, for preservation points. And so my suggestion would be is that, number one, that would be useful in the Court of Appeals, and then merely to put it in the issue statement as to where the error occurred, or something about where it's preserved. That way it doesn't work against the word count. And if it becomes an issue, the Court of Appeals will deal with it. It'll be in the opinion, and it doesn't need to be handled in your petition for review. I think maybe not having in the petition for review is a good idea, because everybody worries the hell about the word count. But I think it would be a very useful, return to the past for a briefing in the Court of Appeals.
Thanks, Roger. Mike Hatchell.
Yeah, Roger is correct that this is kind of deja vu all over again. We used to have this requirement, and I would have to say that at the end of a briefing process, it would sometimes take you as many as 4 hours, maybe longer, to document all of that for an issue which may not even come up on appeal. So it's enormously expensive to the practitioner to have to document all this. The rules already provide that you give record references, appropriate record references to factual statements and arguments that you make. So it's already there. But Pam is absolutely correct that this is just not easy to decide. So if you omit something, then now our court's going to start throwing you out of court because you forgot to put something in. Just in my experience, the fights over preservation are very few and very easily determined. So I don't see any reason to go back in history and start this extremely expensive and perhaps largely useless process all over again.
Thanks, Mike. Frank.
The direction from the court just said citations, and I thought that was ambiguous. I mean, there's citations to the record and there's legal citations. Everybody here who practices in the Supreme Court says, oh, this means record citations. Well, it needs to, if the court puts something like that in here, it needs to say citations to the record, because there are people who maybe don't practice as often in the court who look at that and say, oh, I've got to have legal citations to support preservation.
Thank you. Kenan.
My spacebar trick also did not work, for the record.
Who suggested that?
It's a good suggestion. It works sometimes, but not all the time. But I digress. I will say, from the State Bar Court Rules Committee recollection I have, there was some strong opinion from the staff attorney at the Court of Appeals about needing this information because there was a thought that it would reduce the burden that's on them. So I throw that out there just because I think when we're considering burden on practitioner, we ought to be equally sensitive to the burden on the court personnel. I'm not speaking necessarily in favor of it, but it was something that struck me as worthy of attention when I was on the Court Rules Committee. I'll note further a slight recollection, and Martha may have a better one than I do here, but my slight recollection is that the discussion at the Court Rules Committee level included an assessment of what the rule used to say and an effort to ascertain why the rule was changed. And we were not able to identify a real good explanation for why the rule was modified in the past. And I defer to Martha if she has a better memory than I do on that front.
I do not remember that.
All right. Thanks. Evan.
Pam had mentioned that when we were thinking about this, we were focused on this at a Supreme Court rather than Court of Appeals level. And now Martha and Kenan have clarified where that came from, but it actually makes me like it even less as an idea, just the idea that the other side isn't troubled by any of these arguments, that they aren't saying that it hasn't been adequately preserved, but some staff attorney is just wanting to be Inspector Javert and go around and find ways to pour you out when the adversarial process isn't that just, I want to double my vote against adding this requirement now.
Okay, you can vote twice, Evan. That's the deal. Roger.
Down.
Well, let me give you a slightly more nuanced approach to the last comment. I have been in cases, and I have seen cases in the courts of appeals where you make an assertion about an issue, the other side joins issue, argues it, never talks about error preservation, and then you get an opinion for the first time and say, well, we don't think you preserved error. Bye. Too bad, so sad. I think it's important in the Court of Appeals because there are clerks who, if they can't find it, they'll tell their judge it's not preserved. And what a nice way to get rid of a difficult issue. And you don't get any answer, and then you file a motion for rehearing explaining where you think you preserved it, and all you do is get a postcard saying so sad. And you never get to join issue because when the first time around they couldn't find it because you didn't tell them in your point of error where it is. So I think at least in the Court of Appeals, it is an important hedge against getting a surprise. And it also means that if the judge or a law clerk thinks you didn't preserve it, well, there it is in your brief explaining where, and they'll have to deal with that. So that's my opinion.
Okay, thanks, Roger. Justice Gray.
The rules by which we live is that we must address preservation first. We frequently don't because there's no argument, but we have to look at that with regard to the issues we address. Please remember that 60% of my docket is criminal cases. Preservation is a bigger problem in criminal cases than in civil cases because there are two types of error, not even getting to charge error, but it's a case called Marin, Category 1, Category 2 that don't require error preservation. Then whether or not it in the charge error, if it was or wasn't preserved, it affects the harm analysis, how you approach the harm analysis. So in the Court of Appeals, if that's what we were actually talking about here, it would be very important because we're talking about petition and not briefing in the Court of Appeals. Frankly, that's after I have to deal with it, so I don't care.
Richard Munzinger. Now you got to unmute yourself, Richard.
Sorry. I agree with Mike Hatchell's comment. This costs time and money to clients. We're talking about the petition for review and not briefing in the Court of Appeals. If there's an issue, the other side will raise it. You pointed that out, Chip, and I agree with that. If they raise it, then you go back and you say, no, it's in this or there or whatever it is. It becomes an issue if raised. If not, let the Supreme Court get on with it and deal with the jurisprudence of the state.
Thanks, Richard. Lisa.
I was about to text Pam, like, was this proposal just for the Supreme Court or was it for the Court of Appeals? I thought it was just for the Supreme Court, but that may have been my own ignorance.
Well, that's how I read it. And I guess if the court wants to refer it back to us to look at Court of Appeals, we can do that. I don't know that I would change my opinion, but our subcommittee could discuss it.
I'm not sure I would either. The rationale for the Supreme Court is that in the briefing attorney's memo, they have to do a preservation section. So if they have that section in their memo, hell, I'm happy to like write that for them and you just cut and paste what I say it happened. And so it's worth my client's time for me to do it at that stage. But to Justice Gray's standpoint, preservation of error that's not fundamental error. And so if the other side doesn't raise it, I don't know why courts of appeals are going out of their way to raise it, because if I didn't, let's say my trial counsel did not raise an issue and the other side, we go through full briefing at the Court of Appeals and they don't raise lack of preservation, I don't know, I kind of think that's waived. Like, but I know smart people can disagree with me and you can disagree with me in a way that a different Court of Appeals might disagree with me, but we aren't talking about fundamental. It's not like subject matter jurisdiction where you actually have an obligation to consider your jurisdiction. So I don't know. I feel like we're going down, if anything, the conversation that we're going down is making me way less inclined to include this, even though I do think it would be helpful at the Texas Supreme Court level, where I know internally within their briefing memos that the law clerks do, they have to include this section.
All right. The subcommittee recommends no change. How many people are in favor of no change? Raise your electronic hand. Oh, Evan's got 2 votes. Sorry. Good point.
Does he have 2 hands?
He has 2 hands. Yeah. Okay, Pauline, I've got 22.
So do I.
All right, everybody lower your hand. Okay. Anybody that wants a change, raise your hand. Okay, almost, Pam. You almost got unanimous, 22-1. So no change. The subcommittee recommendation is followed in terms of our recommendation to the court. So now we got one more agenda item, but I think we'll give Dee Dee and everybody a break. And so why don't we come back at 10 minutes to 4. I'm sorry, 20 minutes to 4. So take about a 15-minute break.
Okay.
All right, great. Thanks, everybody.